Okay, we're going live, and I'm going to assume that we left off on Chapter 9, Title Insurance. After going through some of the different mortgage types, such as like lease to own, installment, land contract, mortgage substitutes, and so the background for title assurance is that the Public Records Office maintains instruments affecting land title to be searched for defects affecting fee simple ownership. The city recorder or equivalent public official is involved. The search of following instruments to probably perform or conduct or allow for the search of the following instruments: a deed, a mortgage, a lien, will, judgment, or lis pendens, which is a notice of pending action, lawsuit pending. Title registration alternatives I have here is the state registers title. The state issues a title certificate to the owner, or the owner reissues the title certificate to a new purchaser. Title insurance is the opinion of the insurer concerning the validity of title, backed by an agreement to make that opinion good if it should prove to be mistaken and loss results as a consequence. Title insurance is issued from private insurance company for a premium. Many keep their own public records office. Next, mortgagee policy is a type of title insurance that insures the lender, not the homeowner. The owner's policy insures the homeowner, not the lender. And the secondary mortgage market purchasers require lender's title, and a standard policy, as opposed to like a limited policy, has extended coverage. It's purchased at a higher premium. It will guard for losses, but not. It will exclude losses from the government regulations such as use, zoning, code, unless in records, and then excludes claims of persons in possession not in public records, and records, easements, implied easements arising from prescription. And extended coverage is purchased at a higher premium. I said that, but you tend to have this standard policy when a property hasn't been conveyed in a while. But if it has been conveyed within recently, you might not need so much coverage because it was just recently conducted. You could get a more limited policy, which costs less and perhaps is a little bit of a more abbreviated search. Now, a case on point is Walker Rogue Inc. versus Chelsea Title and Guarantee, in which the title company that didn't provide an endorsement for abstract of title is not to bear liability for boundary discrepancy that should have been found during the title search. There is a split on negligence liability and duty on title insurers to disclose defects, and endorsements are based on survey being available. So that's probably a big differentiating factor between a standard policy and a more limited one, or an enhanced policy, I should say. Negligence is failing to record in a timely manner errors in title commitment, but not decisions. Investment risk based on purchaser with notice. And IA title guarantee certs replace title insurance. I'm going to move into the next section. Well, actually, before the next section, I just have a note here about marketable title acts, which limits the period for title search to a reasonable period to find adverse claims, and it works as a statute of limitations, only subsists of 30 to 40 years. It limits the title search from going back to the beginning of time to a 30, 40-year period. Recording system. Recording gives constructive notice to all later purchasers. Introduction. England adopted after U.S., and before that, deeds handed down, stored in boxes in office of owner's solicitor, and the recording is not necessary to give effect to the conveyance. Copies of the deed are inadmissible. Copies of deed are admissible. Notary attestation for integrity. So these are all kind of developments within this recording system. Common law or equitable doctrine of bona fide purchaser, protected against prior unrecorded interests. And here you see the prior in time, prior in effect quote. The indexes, there's different indexes in the recording system. There's a tract index, which goes by the parcel ID number. There's a grantor-grantee index, which goes by the surname. There is a so these are stored in volumes by date and sometimes instrument type. EA reference in index to a document instrument contains essentials. So I forget what EA stands for, but here's the essentials that you would find on like a record. Grantor, land description, date recorded, grantee, instrument type, volume, and page number. And then index to a document or instrument. And then to find liens, search grantee's name back and then grantor's name forward for unsatisfied mortgages. I have here also CERLA contamination records, etc. So you're basically looking for quote encumbrances. Those are two examples of encumbrances. The Luthi rule is a rule that when it appears to be well established that the absence of statutory provisions to that effect an index is not an essential part of the record. In other words, a purchaser is charged with constructive notice of a record even though there is no official index which will direct him to it. And that's from Luthi versus Evans. So again, the rule appears to be well established that the absence of statutory provisions to that effect an index is not an essential part of the record. In other words, a purchaser is charged with constructive notice of a record even though there is no official index which will direct him to it. So why is this important? Because I feel that I've learned the direct opposite. Like if a deed cannot be found by a title search of what's at the records office, it's been recorded, I don't necessarily think you would be charged with notice of the record. Right? So I feel like this Luthi rule is the opposite of that, but it just kind of goes to show how things are going to go back and forth. I think for the bar, I've been learning from experience that you're not charged with knowledge of things you can't find because they're like misfiled. But you are expected to do a thorough search of things that can be found. So you will find things that are recorded properly, but you might not find things that are recorded improperly, and you would not be charged with notice. You might be charged with inquiry notice, though, which means that if you're looking for something and it's not there, that you have to be on inquiry of the possibility that something is wrong and that you should you should insure that risk. So construct a trust action for first purchaser to take money paid by the second purchaser to the grantor that was unjustly enriched by both purchaser for same principle by recording error and recorder protected by immunity. That, I don't know what that's doing here. It's number 6 under an outline with a section title. I don't know. This is what the sixth point under the recording system. Actually, it's the 7th point under the recording system. So let's just read it again. As it relates to the recording system, a constructive trust action for a first purchaser to take money paid by the second purchaser to the grantor that was unjustly enriched by both purchaser for same principle by recording error and recorder protected by immunity. So point number 8 under the recording system, the U.S. government survey in 1785 was a federal government policy enforced by the Continental Congress for all but the 13 colonies to deed the U.S. into rectangles of 6 mile square intervals, 6 square mile intervals, which I have in parentheses here, township lines, about principal prime meridian, and the correction lines were made due to Earth's natural curvature. And item sonans is that though the person's name has been inaccurately written, the identity of such person will be presumed from the similarity of pronunciation. So, or verse buyers is the example of that. So, to the extent you could be like sounding something out, have spelled it wrong, and not found it in like a grantor-grantee index. What's the effect of that? Is that the identity of such person will be presumed from the similarity of pronunciation, even if there's a typo like in the records recording. So I'm just reading this from my outline. Barbary may not talk about this. We will come to see that. Probably not an essential point. But if it happened in real life, look up or verse buyers, or ORR verse buyers, BYERS, hyphenated debt not serviced at time of transfer in one of 2 last names will not be constructive notice to purchaser, and debtor will lose their right to recover. So all of that was nice kind of background, but the types of recording acts is really the main points to get across in this section. So race statute, notice statute, race notice statutes are the 3 types that are most regularly tested. So I'm about to go into this. Race statute, the person who wins the race to record prevails whether subsequent purchaser or lien holder has actual knowledge of others' claim is irrelevant to limit inquiry into matter off the record. Half the states follow this, for example, Louisiana, North Carolina, with regards to deeds, and other states with regards to mortgages. And notice is not relevant, and the dispute can be settled by recording office evidence. Easy. Notice statute. Actual knowledge of unrecorded instrument eliminates holder's ability to record legal instruments or take land in event of challenge, prevents fraud or fairness for greater than 2, and promotes fairness for greater than 2 claimants. In other words, a late purchaser without notice of earlier claim prevails over earlier taker, not necessarily for later purchaser to record. Half the states use notice statute, for example, Illinois, Massachusetts, Texas, Virginia, Florida. Race notice statutes, the subsequent purchasers protect against prior unrecorded instruments only. Half the states follow race notice statutes, including California, if the subsequent purchaser is without notice of the prior instrument and if the subsequent purchaser records before the prior instrument is recorded. Extrinsic evidence makes cases easier to settle, punishes non-recording, and make records complete. That's probably the public policy initiative. And it eliminates the possibility of later bona fide purchasers without notice. And it protects against claims that arise by operation of law, such as future interest, dowry rights, prescriptive and implied easements, adverse possession. Within the dowry rights, I've written widow, widower's share, and property by operation of law, just in case you didn't know what that was. Types of recording statutes. Without recording statutes, first taker in time would prevail. Okay, so moving on, subsequent purchaser in good faith means in all cases for the second taker to prevail, he must be a bona fide purchaser, meaning he pays money for Blackacre. The shelter statute, however, is when a person who takes from a bona fide purchaser is protected by a recording act that has the same rights as the grantor. Protection that the grantor didn't have noticed at the time of conveyance. So what does that mean in English, since I just botched it? If a bona fide purchaser without knowledge, let's say if that was a relevant inquiry, without knowledge of a previous deed or conveyance that occurred before his, and what wasn't recorded, it is known to that bona fide purchaser, or is not known by the bona fide purchaser, and he thereafter grants by gift an interest in the property to a donee. The donee would rely on the shelter rule to protect their interest. That would mean that the donee doesn't have to be a bona fide purchaser. He's not. He didn't pay for the property that's now ownership's being disputed. But he was given his interest by a bona fide purchaser. So his interest is like protected by the shelter rule. I don't know if I made that better or worse, but generally, as between two innocent parties, the court assigns liability to the one that could have most easily prevented the harm. Now, chain of title problems are going to follow. First definition for chain of title is a sequence of transaction by which title has passed from sovereign to the present claimant. The alternate definition is a more technical: instruments recorded during period of time that must be reviewed in title search in particular jurisdiction or extended search in some jurisdictions to constitute constructive notice to all the world, i.e. to a subsequent purchaser. Chain of title problems number 1 is a wild deed does not give constructive notice because it's not revealed by search, because the search is by the grantor grantee last name, not the address. Chain of title problem number 2, in order for an easement to be effective, the grantee of burdened estate must have notice of it. Chain of title problem 3, must purchase search before a grantor got deed for previous grants. Chain of title problem number 4, when must subsequent purchaser search forward after each grantor's grant to determine who else he may have granted to, for example, after your grantor's grantor parted with it, in quotation marks. Anachronistic deed recording. Deeds recorded out of sequence. Split jurisdiction in Morse versus Curtis of Massachusetts, 1885, would construe anachronistic deed recording as not providing notice. Whereas in Woods versus Garnett of probably Mississippi in 1894, notice surrender by anachronistic deed recording. Persons protected by the recording system. Florida statute protects against unrecorded conveyances on mortgages, creditors, or subsequent purchasers for valuable consideration. California statute protects any subsequent purchasers or mortgagee in any judgment affecting the title. No statutes favor donees devisees over a good faith purchaser, i.e. the bona fide purchaser, except in the case of the shelter rule that we discussed above, but I still feel like that's not going to make you superior to another in competition with a real bona fide purchaser. No statutes favor, bona fide purchaser is a subsequent purchaser that pays greater than a nominal amount or a substantial amount for the property. What is notice? Or here's notice, a section titled notice, and starting with California, latent title defect. If a transfer has actual knowledge of facts showing that the transferor had fraudulent intent, will a purchaser for substantial value be deemed to have acted in bad faith? Latent title defect, if a transferor has actual knowledge of facts showing that the transferor had fraudulent intent, will probably render a purchaser for substantial value to be deemed to have acted in bad faith. I don't know. It's not really a sentence under this California section. So I'll leave it to California. It would be too difficult for me to have written out correctly. Quitclaim deed purchases may never be bona fide purchasers without notice. Because just by the fact of getting a quitclaim deed, you are on inquiry notice that there's probably something wrong with it. Recording Act, states protect purchasers who provide labor or building materials for building project. Inquiry notice, form of constructive notice wherein the law deems purchaser to have actual knowledge. So at this point, I'm just writing down kind of definitions of things. So within inquiry notice, which is again a form of constructive notice wherein the law deems the purchaser to have actual knowledge, couple things, like 5 things written under that, is that constructive notice, record notice occurs when a properly recorded deed contains facts that would cause a prudent person to inquire further. If he does not inquire, the purchaser's still charged with knowledge of what he would have found if he inquired further. And example, quitclaim deed or lower than fair market value may incite doubt in the purchase that would cause a reasonable person to question the credibility of the seller. Red flags, known unknowns, and another example is inquiry notice is presumed if the price paid by the bona fide purchaser was 5% of the fair market value. Inquiry notice is also going to be triggered by another person in possession of the property that you're about to purchase. Inquiry notice is also, and that is always going to be assumed that the purchaser of a property has visited the property and taken note of who's in possession of it. Actual notice and record notice in some cases is really all that I have left here on page 18. Actual notice arises when a person is aware of a conflicting interest in real property, often due to another's possession of the property. And fraud is actual notice of facts showing that the transferor had fraudulent intent. Record notice is the same definition as inquiry notice one has based on properly recorded instrument, based on facts a reasonable person would make inquiry into the possible existence of an interest in real property. And cases Nautilus Inc. versus Yang, 2017, Swanson versus Swanson, 2011. Borsman versus Thompson, 1999. Harvard versus Paradise, 1974. So the next section is going to start with Chapter 11, Private Land Use Controls, the Law of Servitudes, which I'm going to record just a bit later. States